was facing a violent overthrow of the 1962 Constitution. It chose political expediency over constitutional legitimacy. You all remember that in the case of Uganda versus Commission of Prisons, ex parte Matoke. The ruling in that case became the first post-colonial excuse, and every regime has used that to justify the using of guns to either silence or rewrite the law. Friends, you remember some 10 years ago, Professor Lokonyango wrote, and I agreed with him. He wrote about this case and said, in many ways, this case was both an ending and the beginning of Uganda. A very dangerous precedent was set, and it has continued to be an excuse to justify military takeovers and fraudulent elections to the present day. Now, another even more disturbing excuse which continues to impede our democracy is the so-called substantiality test. Under Section 61 of the Presidential Elections Act, the election of a presidential candidate can only be annulled upon proof, among others, that there was non-compliance with the law governing presidential elections, and that, and please listen to this part very carefully, and that compliance affected the election result in a substantial manner. What do they mean, substantial manner? What exactly do they mean? You will note that in all the past presidential election petitions, the Supreme Court of Uganda has always conveniently used this so-called substantiality test as an excuse to overlook the proven and glaring vote rigging together with the electoral violence by the military and the police. All that has always been done in favor of General Museveni, but the court has always overlooked that. Even when they know that every single act of rigging or every irregularity, however big or however small it is, was done precisely to alter the result of the election, and also knowing very clearly that no one rigs the election just for the sake of rigging. They rig it to win. But again, they always bring the substantiality test as an excuse, and they always overlook the facts to decide what they want to decide. Friends, lawyers should have the moral courage to call it exactly what it is: judicial cowardice, dressed as legal doctrine. Ladies and gentlemen, that judicial cowardice is what has failed our democracy, and it has kept our country moving in circles. It ignores the reality that in Uganda, electoral malpractice happens throughout the entire electoral process, from pre-electoral times to post-electoral times. I mean, you see abductions, you see torture of opponents, you see gerrymandering, you see internet blackouts, you see military deployments, you see open briberies, etc., etc. You don't just see the ballot stuffing and rigging on the day of the election. It happens long before, it happens during, and it happens long after. But the courts of law have always closed their eyes to that. If we had the rule of law in Uganda, worth its name, then this was supposed to shake the entire legitimacy of the entire electoral process, but it does not. Unfortunately, the Supreme Court judges always choose to favor the regime just because they feel safe doing that than upholding the rule of law. So, dear land friends, I think it is high time that lawyers stop acting like they are safe in this burning house called Uganda. Friends, you are not safe. In a burning house, in a sinking boat, nobody is safe. So don't even lie to yourself. We are here, but I look around and see that all of you lawyers are just as vulnerable as the ghetto people where I come from. Right before me, Council Mudiogolezea was abducted and kept incommunicado for almost a week. He is a lawyer. That alone is supposed to speak to all of us, ladies and gentlemen. Peter Chibirango was a lawyer, but when he walked into a reckless community, he was suspected to be a thief, and he was beaten to death. Ivan Bakesiga was a successful lawyer in his own right, but when illness came, he was as vulnerable as anybody else. He tried to fundraise, but eventually he died. All of us, who does not remember Bob Kasanga? Yes, he was controversial, but he was a very good lawyer. And he was a wealthy man by any standards. But he died in prison, denied bail, and by extension denied the medical attention that he so badly needed. He passed away. Now, I want all of you present here today and those watching us.
Good morning, ladies and gentlemen. I welcome you on this 24th day of July 2025 to the ULS House for this yet again another session, the 28th session of the Radical New Bar weekly press and public engagement. We would like to thank you for making time. We would like to begin the day with an opening prayer as we settle in. We would like to request that the House come to order in way of beginning the day with an opening prayer. I would like to invite Maggie to come and give us an opening prayer. Thank you. Maggie, please come.
Let's humble ourselves, we pray. Almighty Father, we thank you for the gift of this day. We thank you for the gift of life. We thank you for the gift of Uganda Law Society. We thank you for the gift of council. We thank you for the gift of management. We thank you for the gift of the staff and the entire membership. King of glory, as we gather today for this another R&B session, Father Lord, may you fill us with knowledge, wisdom, and understanding so that we understand whatever is going to be discussed today. We pray, Father Lord, that you cover us with your precious blood of Jesus, that you may protect us against all evil will. We ask this through Christ our Lord. Amen.
Thank you so much, Maggie. We are grateful. Ladies and gentlemen, once again, we would like to thank you for this day that the Lord has given unto us as we rejoice in him. We're here as the Radical New Bar to espouse, as we have always done, according to our ULS section article, the ULS Act, Article Section 3D, to espouse and bring forth access to justice and information, like it has always been the case. Today, we have three very critical matters for discussion, and as is the case, these topical discussions are always facilitated by very, very good experts, and today we are going to be discussing, amongst other things, demystifying the advocates, in brackets, remuneration and taxation of costs regulations 2018. That has always been a thorn in the skin and in the flesh of lawyers, and we shall be hearing more from the experts that are going to be aligned and be presented to the members. We are also going to be discussing about AI and legal tech disruptions, challenges and opportunities for the bar, and also we shall have an expert that is going to be arraigned before us or presented before us for purposes of breaking it down to solubility, and we shall also be hearing about innovation for justice, the countdown to the R&B digital transformation festival, which we are calling the Tech Fest, that was recently launched around 2 months ago at the ULS House. But without further ado, I would like to take the opportunity to introduce myself. I am Robert Benon Jirua. I'm the Litigation Officer, Uganda Law Society, in the Department of Rule of Law and Litigation, and I'll be taking us through the day as the moderator with my colleague Samantha. Over time, we shall be interchanging the roles, but as we go forth, we would like to welcome the head of department, Ms. Afra Pio, to give us the opening remarks in order for us to go forth and get to hear about the next agenda items. Thank you so much. Thank you, Ms. Afra. You're welcome.
Our special guests today, Mr. Fred Muwema, Managing Partner, Muwema & Co. Advocates and Solicitors, Mr. Galandi Tony, Managing Partner, Diamond Advocates, Mr. Godwin Masiko Muhwezi, Consulting Partner, Masiko Wanda and Arinda Advocates, and the Chairperson, RNB Digital Transformation Festival Committee. The ULS members physically present, represented by Mr. Anthony Asimwe, the Vice President of Uganda Law Society, and council members joining us online. Members of the Uganda Law Society joining us both physically and online. Members of the press, ladies and gentlemen, good morning. My name is Apio Afra. I am the Head Rule of Law, Uganda Law Society. I bring you greetings from our CEO, Ms. Christina Worry, who is away on official duty and not be able to be with us this morning. I welcome you to the 28th Rnblive Weekly Press and Public Engagements. Today, we have 3 issues for discussion. The first one is Demystifying the Advocates, Renumeration and Taxation of Costs Regulation 2018. This will be discussed by Mr. Fred Muwema. Issue 2, AI and legal tech disruptions, challenges and opportunities for the bar. This will be discussed by Mr. Galandi Tony. Issue 3, Innovation for Justice, countdown to the RNB Digital Transformation Festival, to be discussed
Recording in progress.
To be discussed by Mr. Godwin Masiko Muhwezi. We shall have a Q&A at the end of each session. I encourage you all to participate and make the sessions interactive. We extend our sincere appreciation to all ULS members and the public who consistently join us every Thursday for these vital discussions. This week, we are also commemorating the 15th annual Pro Bono Week under the theme, Redefining Criminal Justice. A number of impactful activities have taken place across the country, including prison visits, market sensitizations, and community legal awareness sessions. We are grateful to all our members who have actively participated in these efforts to promote access to justice. The Pro Bono Week will be concluded with a stakeholder engagement tomorrow, Friday, 25th at the ULS House, and we invite you, our online audience, to join us as we reflect on the week's achievements and explore ways to further strengthen our justice system. Thank you all once again, and I wish you fruitful deliberations. I now take this opportunity to invite our Vice President, Mr. Anthony Asimwe, to offer his welcome remarks.
Thank you, Afra. Senior Counsel, our guest for today, Mr. Fred Muwema. We are deeply honored to have you here today. Counsel Galandi Tony, okay, we're happy to have you. The members who are here physically, members online, Secretariat, I do bring you greetings from the President, Mr. Isaac Semakade, and the Governing Council of the Uganda Law Society. Thank you for coming Thank you for being here for this Rnblive. And we are deeply honored and glad to have you participate in this. In a special way, Senior Counsel Fred, I made a remark last time we had, I think, one of our Rnblive events where we had, I think, Medad Segona presenting that in the recent past, or since the Rnb, the time of the radical new bar coming into force, we had somewhat had a disconnection between the senior members of the bar and the young lawyers, who are by the majority. So for us, it's such an honor when we have senior members like you coming down to speak to the membership, but most importantly for the young generation, because it shows that commitment and passion and love for the profession. So do not take it for granted. We know you have a very busy schedule, but by the fact that you've agreed to put your time to put your things aside and give us time, we do not take it for granted. Let us clap for him. And I wish we could have more and more senior members of the bar. When we are studying, they used to tell us, even when you go to court right now, they will never call you matter when there's a senior member of the bar. Reason being, we are supposed to learn from the seniors who have had experience, who have seen it all, who have gone through all this. Now, during these Rnb weekly events, we discuss matters that affect our practice and also matters that affect the public, matters of rule of law, because we feel we need to close the information gap. We need to be impactful in execution of our mandate. Robert mentioned Section 3, C, E, and D of the Uganda Society Act. We do not only focus on issues that affect the members or the membership or the practice of law in the country, which is our mandate, but also on a wider, we focus on the wider role of the Uganda Society. What does the public expect out of us? So I do, with all honesty, appreciate the members who have always come out. You notice every week we have a different topic for discussion, and I do believe that what we are tackling today is beneficial for especially members of the bar. When you talk about fees, every lawyer who joins practice, everyone who is, wakes up every morning going to work, they're focusing on earning. But the issue is, how do we earn? How are we supposed to earn? There are ethical considerations. There's procedure. There are so many things surrounding it. But for any lawyer in practice, the most important thing is the fees. And we've seen some colleagues have had issues in this area. Others work, but they've still failed to appreciate, even with the existence of the law, they've still failed to appreciate how to, how to bill, how to handle certain issues. Sometimes you find people in court and you're arguing over fees. Even the taxation, sometimes people appeal and go up to Supreme Court. Yesterday, I had a story of people went up to Supreme Court on an issue of just fees amongst members. So I want to believe that in Senior Counsel Fred Mwema, we shall have this demystified for the benefit of the members. Again, when you talk about digital transformation, and which is by the one of our core focus areas as the Radical New Bar, we have the 4 Ds we focus on, and we'll keep reminding people about this. We have democratization, we have digital transformation, there is decolonization and democratization. We've tried to do our engagements based on capturing these 4 important, the important 4 Ds. So our other discussion today on the, AI and the disruption, it's an area of disruption, is also very vital. We cannot run off from it anymore. I've seen, I don't know if you've seen this, some of us who have people do research, don't get surprised if your research assistant gives you an opinion which is AI generated. And sometimes they've not even taken time to go and confirm whether what AI has given them is the reality. We've seen, a recent judgment where there were wrong citations Yeah, simply because it was generated by AI and AI just captures. So now, this is an area where I need to focus. The regulatory framework for that is still nowhere, but it is an area we must embrace as the profession, because there's no going back. That's where the world is headed, and we need to appreciate how to deal with it. Now, I'll not go deep into that. I am so expectant, and I want to believe that everyone out there is expectant, as I am, to wait on receiving the knowledge and expertise from these important people, from these skilled people in that field. So without further ado, allow me once again request you to clap for the members and also clap for yourselves. And I do welcome all of you to this Rnblive event, and I wish you good deliberations. Thank you.
Thank you, Honorable Vice President, who has been the most perpendicular and ever present. We can all bear testimony, because yesterday I called him a Robocop. Those who were old enough to have watched that movie, his schedule can just not be understood. The day before yesterday, he was in Nairobi, and yesterday, just before we thought we are going to do without him, he was appearing, smiling, like nothing has happened. And today he's here with us. So we really thank you for the task that you're carrying on. It's a very important one, and we pray that the Lord bless you. I would like to pass a message from the president of the Uganda Law Society, Isaac K. Semakade, who has asked that I specifically throw flowers unto Council Muema. He says you are a personal hero to him. He appreciates everything that you have done for him, and he is very, very much excited about your presence here. He welcomes you from the bottom of his heart, and he is very, very honored for the great mentorship that you are offering to the whole new generation, just like the Vice President has stated. But the person we are talking about and throwing so much light upon is a very distinguished legal practitioner for 28 years, working experience with a reputation of delivering effective and creative legal solutions in various aspects of public and private law. He is an advocate of the High Court of Uganda and the managing partner of Muema and Company Advocates and Solicitors, one of the leading law firms in Uganda. He has a strong bias in corporate and commercial practice. He is an ardent litigator, stands out for handling complex cases in corporate finance, investment, and tax administration, intellectual property, constitutional and administrative law. He is also very well known for litigation, and he has handled very many important landmark cases in Uganda. And besides the law firm, he is also the founder and director, Legal and Corporate Affairs, in the Anti-Counterfeit Network Limited, a private sector organization which aims to bridge the intervention gaps between the multiple stakeholders and to create a united front against counterfeit, substandard, and illicit trade. Ladies and gentlemen, to demystify for us the Advocates' Remuneration and Taxation of Costs Regulations 2018, welcome with me Senior Advocate Fred Muema.
Thank you so much. There is no protocol here. We are all advocates, isn't it? Okay, so first of all, I apologize, Mr. Vice President. You're my neighbor here, but I've never been here. I always pass in the traffic. I didn't know you have parking down. Now I've seen there's parking. So tell the guards I'll always be branching to say hello. But a fantastic job that you've done. I want to tell you, I was asking him how much the advocates have contributed to this building. And he mentioned some small figures, 300 million, 500 million. I asked him, what's the total cost? 14 billion. Mr. Vice President, the reason why advocates cannot contribute enough to their own house is because of the poor remuneration that they receive. Blame nobody else, but the terms under which we work are poor. And as I will show, the biggest problem to our problem is us. So 32 years ago, I left law school, and as a young man at that time, I was lured into the profession by the promise of a good life, the promise of service to my community, and the promise of contributing to the rule of law. And what turned out was that despite the important role advocates play in society, I found that we were a marginalized group. If you don't know that advocates are very important, I want to inform you that it was an advocate who swore President Museveni into office in 1986. After risking his life fighting a guerrilla war, to be recognized as president, he had to be sworn in by a British-born justice. I think it was the Chief Justice then. Was he called Peter Allen? He swore him in. And that shows that advocates are very close to power. But we behave like a relegated group that has failed to take its proper seat. And even if in 1986, on the 29th of January, the president said it was not a mere change of guards. I know most of you are not born then. He said this is not a mere change of guards. This is a fundamental change. It appears, however, that the fundamental change has not impacted the lawyers very well. It appears with the lawyers, the advocates have not claimed our fundamental change because we are still subjected to colonial relics and legislation that restricts our proper remuneration and earning. That is the problem. And in the invitation I received, I was asked to talk about decolonizing and democratizing the advocates' remuneration in the digital age. I must say, you, my colleagues, have left me to be a lone wolf in this fight. I have, as you know, I'm sure you've studied about those cases where I have fought for remuneration. I have fought single-handedly to try and put down those archaic laws that stop us from earning, especially on success fee arrangement. For the reason that I am still in the Supreme Court on this matter, the sub judice rule, I think it's also a colonial rule, but it's a good one. It says you cannot comment on the merits of a case before the court so as to influence the outcome. So I will not go so much into that case. Allow me to just give you an expose of my thinking in terms of the issue of remuneration. The first point I need to make is that remuneration is very, very important to guarantee quality of service by lawyers or advocates and any other profession for that matter. But society appears to treat lawyers' remuneration or proper remuneration as a taboo. There appears to be some mob justice against lawyers earning high fees or good fees from a case. If you read some of my decisions, like the one of Shell, I think I had a judicial officer talking negatively about my fees because he compared the fees I was going to earn to the poverty index of Ugandans. I mean, what's the relationship between what a lawyer has worked for and is entitled to the general poverty? So you can see that attitude. And this coming from a lawyer, of course, shows that there is a general perception that lawyers should earn as little as possible, which is very regrettable, or advocates in that matter. And until we push back against this attitude, we shall continue the way we are. We shall continue not to contribute enough to our house. We shall continue to go with bowels asking for alms to support, because we are part of a society with a very high youth dependency ratio. I think standing at 115%, it means that every lawyer is facing the social pressure from society. A lot of dependents. I know many of you, your first salary was claimed by your relatives or your parents or your whatever. It's a big problem. Now, you would expect that society would be interested in us earning better. It's the contrary. They appear not to be interested. And yet, in my view, you cannot expect a quality service, a good service, a rich service from a poorly paid lawyer. A poorly paid lawyer will be distracted by the struggles of survival. They will not concentrate, because instead of burning the midnight candle to prepare for your case, they'll have to run away to make ends meet. And that is how you get the standards of practice going down. And then again, you have the judges complaining. But pay the lawyers well. Make sure that they are motivated to work hard and earn. Unfortunately, our colleagues, the advocates on the bench, or fortunately for them, the advocates on the bench, the judges, for them, they have made progress in their remuneration. We have only one amendment to the Advocates Act since it was passed in 1970. I think it's in 2002. And we made that amendment to provide for access to legal education. I think it was the bar. That's the only amendment we made. But the judges, the advocates who are judges, for them, they have been proactive. They have a strong lobby. Sometimes you see the Chief Justice in the State House pushing the president. We need better pay. We need better retirement benefits. And they have gotten something. If you look at the Administration of Judiciary Act, if you look at the long title, the objective, among others, is to strengthen the judiciary in respect of provision and management of funds to improve performance. You can imagine, the advocates who are judges have gotten a law that is supposed to strengthen and improve funding, including their remuneration, to improve performance. You look at your Advocates Act. What does its long title say? Very flat. It just says an act to provide for regulation of advocates and to make general provisions in relation thereto. Your own law does not highlight the importance of your welfare, the importance of your remuneration. It's very generic. And because of that, our twin brothers, the advocates who are judges, have better terms now. I know some advocates want to apply to go to the judiciary. Why? Because of the better remuneration, medical, housing, education. Even when you retire, you have a big package. For us advocates, when we retire to a fate unknown, because we've not been able to save enough due to the social pressures. We've not been able to earn enough despite working hard. So that is the disparity that we have. And so, in my view, if you pay lawyers poorly, or if you sabotage their proper remuneration, please don't demand quality service. Don't insist on quality service. And I'm not just talking in terms of lawyers, any professional. You've seen doctors going on strike all the time. The quality of healthcare is affected by poor pay. Even judges themselves in the past have been grumbling because of the same thing. So in my view, I think that we need to decolonize our minds. We have a lot of intellectual colonialism that is affecting us. We fear to fight for our rights. Most lawyers here are very timid. They cannot stand up for what is right. I'll leave you with a quote of a Mexican painter. She was a disabled lady in the 50s in Mexico called Frida Kahlo. But she was an activist who was fighting for better conditions for her ilk at the time. And this is what she said: the man who does not fight for what he wants does not deserve what he desires. The man who does not fight for what he wants does not deserve what he desires. Are the advocates in the bar or on the bar fighting for what they want? Do they deserve better pay? Yes. Are they fighting for it? The answer is no. In 2015, not 2015, let me go to 2021. In May 2021, the Uganda Law Society sent out letters to many advocates asking for comments on the proposed amendments to the Uganda Law Society Act and the Advocates Act. We submitted, I did submit proposals in a 20-page document. This document, I'll leave it with the Secretariat. On the 3rd of June, I gave proposals to the Law Society on what needs to be changed in the ULS Act and also what needs to be improved in the Advocates Act, especially with relation to remuneration. I will just briefly, of course, I tackled things like digital, which you're talking about, non-lawyers performing legal work, artificial intelligence, paperless practice, data security, all those issues. But when it came to innovative, what they call innovative fee agreements, you guys, because of intellectual colonialism, you still call it champati and maintenance. In other jurisdictions, it's called innovative fee arrangements. This is what we said. In many jurisdictions, advocates are allowed to enter into innovative fee arrangements, which include no-win, no-fee agreements. We continued to say, this was 4 years ago, so I don't know if Law Society followed up on this. These arrangements go a long way in helping clients access justice in the courts and for advocates to secure instruction and fees which could not otherwise be paid in advance. What we were saying to the Law Society was that by having an innovative fee agreement, you allow a client who otherwise would not afford to pay you upfront because legal services are expensive to be able to obtain a service, and once they are successful, you also earn. And we said in Uganda such agreements are still declared illegal under the outdated and medieval English doctrine of champati. But we still have it since 1970, and you can imagine we passed this act in 1970, the current version, under laws of Uganda. Before that, the advocates were still being regulated in a similar manner. And I will not go so much into the technicalities of the provision because I'm still at the Supreme Court challenging this unfair, uncouth provision, in my view. And when we submitted these suggestions to the Uganda Law Society, the lawyers, do a petition to the parliament for lawyers to support a motion. We can have a private member's bill to support a motion to bring down the rules or the provisions in the Advocates Act which condemn a success fee remuneration agreement by an advocate. I don't think there is anything unethical about it, because the basis in the medieval times for these provisions against maintenance and champati was to protect the judicial system, which was weak at that time. But at the moment, you have the checks and balances, you have a strong judiciary. There is no reason why an advocate should be denied opportunity to offer their labor in exchange for a reward if they win. This is happening in all other jurisdictions, including the jurisdictions from where these principles came from. Now, so for me, I feel strongly that we need to take action on our own. Nobody is going to fight for our rights as lawyers. You all go for the ULS meetings and seminars and so on. I don't attend most of them, but you come out not with the kind of resolutions that can help to grow your business. You're busy fighting about, I don't know who is doing what or what, but you're earning. You're not caring about your earning, and you expect some good Samaritan to come and help you. Do you know that the auctioneers, you look at the auctioneers' rules on fees, do you know that they earn more than lawyers? The percentage they're entitled to, go and compare it with the advocate's remuneration. And we are busy sitting, driving Mercedes and so on, but we are empty. We are empty, we are not doing enough. So when we sent this proposal to the Law Society in June 2021, 2 months later, the Constitutional Court dismissed my petition, which was challenging Section 55 of the Advocates Act that invalidates a success fee remuneration agreement. And that also challenges Regulation 26 of the Advocates Professional Conduct Regulations that also declares success fee agreements illegal, basically. This was 2 months after we sent these proposals. And the Constitutional Court, which is comprised of advocates who sit on the bench, said that an advocate, because we are saying that you are hindering our right to practice our profession under Article 40. And in their reasoning, which you can get from the case, they say that Regulation 26 and Section 55(1) of the Advocates Act do not infringe our right to practice our profession, because they still allow us to practice, but in accordance with the law, the restrictive law. And even if at that time we argued in the Constitutional Court that this was discriminatory against advocates, because surveyors, they can survey for you your land, and you give him part of the land after surveying if you don't have the money. We had argued that even the Contracts Act, which had been passed in 2010, allowed for contingency agreements. In all other cases, contingency agreements are allowed. I'm sure even our contractor here has signed some form of contingency agreement. The mere fact that certificates are issued after completing work means the man has promised, if I do the ceiling, you pay me, you know, and then you pay him based on that. So contingency agreements are a common feature in our society. So for you to single out a few people and say that they cannot earn from a contingency arrangement where if they succeed they are paid is, I think, the gravest injustice that you can place on a lawyer. And as far as I'm concerned, those provisions are redundant. They are like the Nguli Act. which has been on the books for, I don't know how many lawyers have, advocates, have prosecuted or defended somebody charged with taking a nguli, but it's there. The Witchcraft Act, all those redundant laws. Why should we, as advocates who know better, allow this kind of thing to be in our midst? But like I have said, it is because we are victims of intellectual colonialism. And so when the Radical New Bar says we need to decolonize the advocates' remuneration, I add on that we need to first decolonize the advocates' minds. They are too timid to get what belongs to them. And I don't think you can be a pleader for somebody if you cannot plead for yourself. Because of the weaknesses in the landscape on remuneration, we have failed to push for an amendment of the Advocates Act to remove the restrictive provisions on remuneration, but we have allowed the amendment of the Advocates Act to give access to foreign lawyers to come here and encroach on our space. The Law Council passed what they call the Advocates' Professional Requirements for Admission of Persons Enrolled in Foreign Jurisdictions, Regulations, SI 4 of 2022. Previously, under Section 18 of the Advocates Act, an advocate who is foreign would come and ask for a temporary practicing certificate for a particular case, quite controlled. Now, you guys have passed regulations, which I think is Regulation 6, allows any foreign lawyer, provided they have practiced for at least 5 years in a Commonwealth jurisdiction, to come here and apply to be enrolled without complying with the conditions, the stiff conditions that a Ugandan lawyer would go through for eligibility on enrollment. These regulations allow a foreign lawyer to apply for enrollment directly without restriction. So you guys, you are making your situation go from bad to worse. I have seen some lawyers complaining they are working in the oil and gas sector and they are receiving breadcrumbs. The foreign law firms are taking the big chunk of the fees. The Ugandan lawyers are doing the labor of most of the work. In fact, I have had one government official defending the hiring of foreign lawyers. I hear because the Ugandan lawyers are not competent. And still we are here sitting. It's a nice thing to build a nice house like this one, but if you are too broke to even pay for power and to even pay for tea and so on, it doesn't make sense. We need to have a beautiful house like we have with money in our pocket. And so I am thinking that we need to have a radical new bar in the true sense of a radical new bar. A radical new bar should not just be about political rights. This one was beaten, this one wasn't given access. It should also be about economic rights, first of the members of the Radical New Bar. If the members of the Radical New Bar are not well facilitated or looked after, I don't think that the Radical New Bar will be able to have a strong constituency to support its initiatives. So can the Radical New Bar lead the initiative of scraping the restrictions on remuneration? I think that's my takeaway. Can you please lead this? Just do a petition. I'll be the first to sign. If you want me to sign, get 3,000 lawyers to petition Parliament. Let us go to Parliament and say, please, you are the guys with the mandate of making laws. Change this law Because even the MPs and everybody else in society is a beneficiary of success fee agreements. I would be very happy if after I leave here, I receive in my inbox that petition. I'll sign it, and I'm sure Parliament can be able to change that law. Let's not leave everything in the hands of our twin brothers, the advocates on the bench. Because the advocates on the bench, for them they say, you must only earn based on the law. If the law says you cannot do a success fee, sorry. The advocates on the bench, we know, sometimes they can be progressive. Sometimes there is what we call judge-made law. They can also make law. But in this case, they are saying no. The law says you're restrictive, you're restricted. Let's do something. So, as I conclude my story, of course, we have filed, or I have filed a petition, an appeal to the Supreme Court, sitting as a constitutional appellate court. Those who want to follow the matter, it is constitutional petition number 1 of 2023. And in that petition, I am saying in part that the justices of the Constitutional Court erred in law and fact when they held that Section 55, 1 of the Advocates Act, which outlaws contingency fee agreements, did not discriminate against advocates' freedom to practice their profession, contrary to Article 40, among others, of the Constitution. And the second ground is that the land justices of the Constitutional Court, when holding that Section 51 did not limit the rights of the advocates to give their labor, and also the right of the clients to agree on terms they can manage on engaging an advocate. I cannot comment further on that petition because we have just finished making the submissions before the Supreme Court, and we are awaiting the decision. But either way, if we don't get a favorable decision, we shall continue to fight on until that law is struck down by whatever means possible. So, in conclusion, I would like to say that advocates' remuneration is essential to the provision of quality services. Just like our twin brothers, the judges, in their law, they said that proper funding of the judiciary is essential to promote their independence. I want to say here also that proper remuneration of advocates promotes their independence. And when an advocate is well remunerated, is independent, they are able to offer a quality service to their clients. A lot of the professional misconduct and unethical practices of advocates is in big part due to their poor remuneration. I would like to stop seeing lawyers on borders and all those things, because we are land friends. We are supposed to be in a certain level. So if somebody is going to struggle like the rest of the folk, then I don't know that he will take a proper seat in the place of the noble profession of advocates. So, since the Radical New Bar is known for action, I challenge you to take action. In this area, don't leave me as a lone wolf. I'm soon leaving the stage. I would like to leave a better landscape for young lawyers to practice. So join me, use your numbers for us to push away the colonial relics of champatry and maintenance, so that we can exercise our true freedom. I would like to thank you and end there. I can take a few questions now. Okay.
Wow, I think that hand clap was insufficient. I ran out of words to respond to what Council has just presented. If there's anything that has touched myself and the faces that are here, it is that aspect of remuneration. Wow. Another hand clap. Thank you so much, Council, for demystifying indeed in a very short way, but also touching very critical aspects, especially for the bigger percentage of young lawyers. Because, I mean, we are over 70% of young lawyers, which leaves a lot to be desired. And Council, for you to know, all this information is not within the purview of the young lawyers. So I can attest that they are surprised that all this is going on. They are surprised that you're standing alone, the lone wolf you've said you are. Would like to thank you for this opportunity. Would like to thank the Radical New Bar, of course, through the leadership of Isaac Semakade, for bringing forth such an opportunity for us to know that wherever we are going, if we don't fight now, next time we shall be walking, and our souls will be like the floor itself, instead of getting Mercedes Benzes and, you know, avoiding borders. Because the borders are also very risky. There's a time a client refused to pay an advocate because he came on a bike. His hair was brown, you know. A lot of things were not adding up. And the man just said, no, Council, you don't deserve this money. And you can hear where it is coming from. So we thank you so much, Council. You have left so many things for us to manage. The very important one is the petition that you've asked us to join you and take lead. We would like to, in the presence of the council member who is the treasurer, who we call the governor of Bank of Uganda Law Society, Honorable Arthur Isiko, is in the house discussing with Council Fred Muema. I think they're discussing the petition. We're going to be looking up to the council member. We'd also like to welcome the council member in representation of the Northern Region, Council Emmanuel Omiad. Thank you so much for making time. You have braved the journey from the north. We take cognizance of your presence. We're so grateful that you're able to come and be with us. Ladies and gentlemen, we are in a question and answer session. I know there have been very critical aspects that have been raised, and I believe there are some questions. We'd like to continue to thank you all for your presence. We'd like to thank the online following. We'd like to thank the press that are here with us. We'd like to thank the staff and the secretariat, and would like to welcome questions for a very short time. We are also aware, Council has let us know that he has a busy schedule. Would like for him to take those questions, and we'll see if we can demystify further with the minds of the members that are here. Any questions in the meantime? Yes, please. You can come forth.
Hello. Good morning. I think, is it morning or afternoon yet? Uncle Fred, how are you? Chako banjaza LDC. Tugena mutamu 4. Thank you, Uncle Fred, for those inspiring remarks. Members earning. And I think this is what we have been talking about. I am a member of the original Radical Bar, the original 3. It was me, Senior Counsel, and Malema Birizi. We are the original Radical New Bar. Members earning has always been key and critical to what we talk about. Thank you for fighting so much. I hope your petition includes the right to advertise as well. Now, one issue came. You are aware of the students' practice regulations. They also prohibit students from earning from the litigation. As you've said, you want to get rid of these champatas agreements. Why don't you also advocate? Because, as you said, you're going to leave, you want the young lawyers and the students to also fight. Some students have students practicing certificates, but LDC sort of restricts it to their legal aid. Yet it's supposed to be to all, including law firms such as yours with Council Kagoro. Now my question to you is, can't you also advocate for the young lawyers, the students, to also earn from the litigation? Because the Advocates Act provides for earning of the advocates, for the lawyers, and I think also for the clerks. So can't you also put that in your petition, Council? Then secondly and finally, Council, honestly speaking, as you have said, the lawyers themselves are the problem. Our brothers on the on the bench, sorry. They have their issues as judges, as judicial officers. Isn't there a way you can engage them? Because they made their own act, the Administrative Judiciary Act. Lovely, when you look at it, they even keep on earning after they leave the bench. So, can't you create a platform whereby there's a sort of, fund for lawyers after they retire, maybe a benefits retirement fund, because the one which is there currently, I don't think it meets the standard, but something which can make the advocates keep on earning even after they retire, because we're not going to remain, young forever. We shall push on. And also think about splitting the bar, because your issue, I think, also touches on, we have a unified bar in Uganda, but in the UK, where we get these things from, they have a split bar. So if we had a split bar in Uganda, don't you think a split bar can, to a certain extent, sort out some of those issues? People who love court, they go to court. The rest who like outside, it is ring-fenced, what do they call them? The non-contentious issues are ring-fenced for the non-practicing advocates in court, and the practicing advocates remain barristers in court. Thank you, Uncle Fred.
Thank you so much, Shamil. Council would like to request that we take a number of questions so that you can run through them, if it's okay. We have a question from one Chiyonga Mark that reads, I'll read as it is. The word on the street is that lawyers are thieves in courts. And to a great extent, it is true because of the many cases reported at Law Council of lawyers defrauding clients. Shouldn't we first focus on improving ethics and advocates' integrity before fighting for higher remuneration? That is Chiyonga Mark. Thank you so much, Mark, for your question. We receive it and we hope it's going to be answered. There is one Atim Mildred who says, thank you, Mr. Muema, for the very important discussion. But the general economic situation in Uganda is bad. Sometimes you want to bill a client, but the client is needy. How can we have better remuneration when the clients we have are also struggling and cannot afford the fees? Majority of us are now seeking opportunities outside Uganda because there is no money in our economy. Would like to request that you take those, then we can get others later. But the microphone before you can be activated, if it's okay.
Okay, thank you. Who was the last
The last
responder?
is Mildred Atim.
Mildred Atim.
Yes.
Very good point you raise, and that is the very reason why we are saying that free up the space to allow clients who cannot afford to pay lawyers in advance to be able to negotiate for other terms. For example, if it's a land matter, 10 acres, you don't have 10 million to pay the lawyer, you enter into an arrangement where the lawyer takes on the case, and if he succeeds, he takes 1 acre. That is answering exactly the pain point that most Ugandans have. Most Ugandans will not be able to afford the services of a lawyer. The current structure of remuneration for lawyers is that I must take an instruction fee. And the instruction fee, if I recall very well, is anything maybe 2% or 5%. So if you subject a Ugandan who is already having difficulty, they have stolen their land or they have taken their money, and then you also tell them, first pay me, it's making it harder. So Mildred and others out there, our fight is not a fight to squeeze clients or Ugandans to pay us more or to pay us at whatever cost. Our fight is to promote the freedom of contract, to allow for contingency agreements. If a client cannot afford, and it is okay with you, you have the capacity to take on the case and do it well, then you take on the case. And if you win, there are arguments which have been made that it's unethical for a lawyer to have an interest in the outcome of a case. But those arguments are not absolute. Because if I know that my payday will come if I win this case, I am going to burn the midnight candle to make sure that I present the best case and win for my client. That's a counter argument. So, and besides, like I have said, this Advocates Act on Champate is like the Nguli Act. It is a useless law because even today transactions are being made in real estate where people are taking percentages. Cases are being, when I was preparing my petition, I went to the law council and I found so many Champatas agreements there by all the leading law firms, the small ones, the medium ones. Everybody does it. We know that laws are made to serve society. So if a law is no longer serving society, like Mildred has said, people are poor, then why don't you open up the space for them to agree on innovative fee structures? Mr. Mark, word on the street, that is symptomatic of what we lawyers call hearsay. Because for us, until something is proved, it's just a word on the street. He called it a word on the street. Now, that's a perception. That's a perception that lawyers are thieves, but like I've explained, a big part of the reason why many lawyers engage in unethical practices is because they are not comfortable where they are. One of the methods used to fight corruption outside the law space is improvement of remuneration, for example, of public servant or whatever. So remuneration is a key factor. To say that let us first clamp down on unethical conduct before we can address the proper remuneration of advocates is like putting, what can I call it? You're not treating the root cause of the problem. I want to say the root cause of unethical conduct is poor remuneration. So start with the remuneration of advocates alongside the sweeping to make sure that they comply. So it is not true that lawyers are thieves, as it is said. I can also tell you that there are so many clients who cheat lawyers. For the 32 years I have been in practice, there are many cases I've had where I do work. When it comes to payment, the client doesn't want to pay. But is it right to say that clients are thieves? Those are just a few. So we also have a few lawyers who are thieves and a few clients who are thieves. But let's concentrate on the positive. How do we make the relationship, advocate-client relationship, better? The clients want a good service. I can tell you, if you want a poor service, you are likely to get it from a poor lawyer. It's as simple as that. So let's improve the remuneration of the lawyers to improve the quality of service.
Thank you so much. There were some questions before the two that we read, the ones from Shamil.
Oh, yes. He's called Mr.
Shamil.
Mr. Shamil. This is what Uncle Fred can tell you.
Yes, Uncle Fred.
Yes. You see, our petition was already crafted along two grounds, challenging Section 55 on Champati and Regulation 26. I don't know that I can apply to amend it now when we have already submitted. We are waiting for ruling. But you raise pertinent issues on the student lawyers. I think there is a need for if you're to succeed to make student lawyers to earn, I don't know where the starting point would be, but you may need to look into the whole protocol under the Advocates Act, because in order for you to be able to charge and even file your bill, you need to have a license. I think you've seen cases where advocates without a practicing certificate are not entitled to fees. You've seen those cases. If you didn't have a PC and you did a case, you don't earn fees. So you can imagine an advocate who is enrolled and has no PC doesn't earn. What about a student who was not even enrolled? And of course, they have a temporary practicing certificate and they have not. So I think that this has got to be done as a project of increasing access to justice. You see, like how we used to have the paralegals. They were not lawyers, but they could go to court and stand in for an accused and, you know, those kind of things. I think it takes more than what you're asking. I don't see that our brethren, the advocates on the bench, can make that policy change that you want. I think that has got to be a movement from down to demand for that kind of change, because we have 5,000 lawyers practicing about 3,000. We are 46 million. That is one lawyer per what? 200,000, 300,000 Ugandan. So we need more and more people in the space, even if they can offer it at a lower space, a lower level, like the students. But because of our adoption of these colonial mentalities, even those things that you're talking about of splitting the bar, I know that in other jurisdictions they have the solicitors associations, they have the barristers, but again, we are too small as an economy. If you are a lawyer who cannot do a little bit of everything, you cannot do solicitor and legal, you may not survive. And I think we also need to push for, this is a sideshow, litigation funding. Litigation funding is a very popular means of getting cases through the legal system to get them adjudicated. But again here, because we are still backward, you have a very good case, somebody has the resources to pay the lawyer and support it, but I know we still do it. There are people who put money in cases. The only problem, again, they ask for 50%, some Shylocks, 30% of the proceeds. But we need to be open. If we're in the digital age, it's a global village, we need to adopt some of these best practices that are applying to our profession so that we can take our proper place in the international bar.
Thank you, Counsel. The aura with which you speak, the passion with which you speak exudes confidence in us to know that it's not a lost cause. If we have our seniors that are still fighting for us, then we go back to appreciate the quotation you gave us. The man who doesn't fight for what he wants doesn't deserve what he desires. Thank you so much. There is a question here from Obed that reads, as young lawyers, we are told to be patient. Colleagues, money will come. The struggle for money in our career is also influenced by the very big numbers of emerging lawyers. Currently, there are about 18 universities that teach law and 3 LDC campuses. Young lawyers in ULS are over 50%. Many young lawyers are getting discouraged and switching to other professions. What is your view about limiting numbers and reducing numbers of those who become practicing advocates?
I think that we need to give proper context to those metrics that Obed is talking about.
Yes, please.
In 1990, when I joined law school, we were 43 or 44, the whole country. And it was one law school, one university. And by the time we graduated, the number was even less. The only thing is we had some people who had not gone to LDC at the time. So you can see 44 or 43. But what was the population of Uganda in 1990? I don't think we were 20 million.
Around 15 million.
Okay. Right now, we have in the 18 universities, probably, I don't know the figures, 1,000 students?
800 on average.
Okay. Let's just say 1,000. So if we now have more admissions to law school, but serving a bigger population, the president always says the economy of Uganda has grown 40 times, 20 times. So meaning that there is more opportunity. Even if the lawyers are many, there is more opportunity to serve. Many areas of Ugandan society, if this was a banking service, I would say they are unbanked. What's the equivalent of they are they don't have legal services. Legal services are just here in the urban centers. So I rather think that the problem is not in the numbers. And again, you have numbers for people scrambling for a small piece of cake. If you can expand and improve the remuneration in the legal practice, it will be able to absorb and provide enough for even 10,000 lawyers. Even if we had 10,000 lawyers or 20,000, it is still a small ratio to the population. So I think we are holding the stick from the wrong end to look at the problem as the numbers. The problem, I think, is the poor regulation of advocates in terms, I will stick to remuneration. Remuneration is the habinga of everything, good or bad, in the profession. Let's try it out and improve remuneration, and then we can absorb the 1,000 lawyers and allow more clients to also access lawyers and to access justice, especially those who cannot pay. But you can't stop it. I don't think the solution is to, maybe the only thing is, for me as a practitioner, I will say here to the young lawyers that the quality of practice among the young lawyers is very, very low, unfortunately. And why? Because many young lawyers are very impatient. Law is a very sensitive, very jealous profession. I know most of you in the digital age, you are used to downloading something, you ask AI, but you're not going to gain experience without the doing part, the hard labor of sitting down to read, putting in the hours, being present in the court and so on. There's no shortcut. But a lot of the young lawyers want to do things very fast and move on. I mean, it takes on average 10,000 hours for you to gain expertise in anything. That's 10 years. But a lawyer has finished this June, and by December he's already posting on TikTok, I have gone to court, I argued this case. The man has no content as yet, but he's already promoting his social media handle. How he's a lawyer. Today I went to Chifuma Court, I submitted like this. Man, what will people who have done 40 years say? Okay? So, no, I am, fortunately, I say it as it is. I don't know how to sugarcoat things. I say it as it is, and what I'm saying is the truth. If you think otherwise, you can have your truth, but that's what I know.
Thank you so much. A round of applause for council. Do we have any questions in house? Yeah, there's a question here. Richard is an ardent follower. It's okay, you can move forth if it's well.
Thank you, Senior Mwema. Since it was pleaded that you've been dealing with complicated things, and I've been one of your fans, I've been following your digital stamps activity. I find that area to be very complicated, even for me. I want that you give the benefit of the young lawyers in the house. I followed your recent presentation in the convention on counterfeit. It was big. The other day, Uganda Law Society was training international food law, and I was following. So these quality mark certification and counterfeit activity on the digital stamps, because I've seen you engage a lot with URA, the back and forth. Maybe you could give us about 3 minutes so that we understand what it is of that area of law. I thank you, Senior. Baguma Richard Ruatori is my name. I sit across the valley at Kalenda and Company Advocate. I'm a non-advocate. I'm a Master of Law student in University of East London. But I've been practicing policy my entire life. Thank you.
Maybe I can take one more question if there is, as I wrap up.
Council is not going to have so much time with us. Any other question? If there isn't, he can take that and we can conclude. Any other? All right, Council, I think that's it.
Okay. The question of counterfeits and substandard is very close to my heart. Actually, outside of legal practice, outside of football where I was and other things, fighting counterfeits is my thing. It is a very big problem that is not understood at all. What have we done as the Anti-Counterfeit Network? We have supported the bringing of a private member's bill to Parliament, the Anti-Counterfeit Goods and Services Bill 2023. I think some of you saw me on the TV, moving to Arua, moving to Soroti, consulting the public about this law. We are the only country in the East African community without a law that defines counterfeits. So you can imagine, Richard, if you're telling me to talk to people about the dangers of counterfeits, as a lawyer, the first place would be, how do you define a counterfeit? You don't have a law. You're the only ones, the only black sheep without a law. So what we have done in the bill is to define counterfeits in a very broad spectrum. In simple terms, counterfeit is an imitation of the original, meaning that if somebody forges the trade dress, the label, goes to NASA Road and prints something and calls it a detergent, whereas it's not, they're counterfeiting. And it involves all aspects of the supply chain, from production until it reaches the consumer. What is our role as advocates in fighting what I would broadly call intellectual property infringement? Of course, we can plead for the genuine product manufacturer. We can go to court, get Anton Pillar orders, get infringement actions filed. But we can do more, because I can assure you that as you live here, most of you are going to encounter a counterfeit. If it's not a cosmetic, I can see some ladies with the lipstick here. We have a lot of fake lipstick, which has, I'm not discouraging you, but I'm just calling a spade, which has heavy metals like lead. And by the way, the most dangerous counterfeit is the cosmetic. When I was speaking to the NDA, I told them that the drugs, yes, they are bad, but you can go a day without taking medicine. But you cannot go a day without taking a shower. Even mad people, I think, shower a bit. They do. So when you shower, the shampoo that you use, the soap that you use, the Vaseline that you use, all those things that you put on your skin, because the skin is the largest breathing organ. It's not your nose, the skin. Anything you put on the skin goes into the bloodstream, okay? And when it goes into the blood stream, the results you can see. Go to the Cancer Institute. Cases of leukemia, cases of skin cancer, cases of... So, the cancer burden that we have, Richard, in this country is because of counterfeits and substandard. A lot of the food we eat, you guys are going to live here, you're going to enjoy your legumes, the beans, you're going to eat posho, you're going to eat rice. A lot of these products, because of the poor post-harvest handling from the garden to to your plate, there's a lot of contamination. There is what we call aflatoxins. Okay? If you see maize, it has some green, that greenish thing, especially if the storage is poor. That's an aflatoxin. Now that guy, even if you dry the maize, even if you cook, even if you take to whatever machine, it stays there. Now that aflatoxin has active carcinogens that cause cancer. Okay? So the cancer issue we are having is down to what we are eating. And it is so bad that even for lactating mothers, the breastfeeding mothers, if a mother takes porridge where the maize had aflatoxins, the mother passes the contaminated food. The milk is contaminated and it goes into the child as well. Same to the meat, same to the eggs. So I can talk about this for 2 days. Clear. My call to advocates, please support the Anti-Counterfeit Goods and Services Bill. We are hoping to go for first reading in Parliament. We have, as the Anti-Counterfeit Network, created a digital platform that we call BLEEP, B-L-E-E-P. The platform is intended to help you report a suspected counterfeit. Because right now, if I bought a fake product, I have nowhere to report easily. So you take a picture and put on that platform called BLEEP. When we receive the report, we escalate it to the brand and ask it to verify. Is this your detergent? Is this your soap? Is this your... And then, after the verification, it can support remedial action. So action can be taken by the brand owner, by the UNBS, by whoever. Talking about the stamps, we have also created a tamper-proof product mark. Unfortunately, most of the QR codes or most of the marks you see on the products are not tamper-proof. They can be cloned, unfortunately. So we've taken some time to develop a secure mark that we shall be introducing very soon to be on the products, so that if Mr. Isiko is buying a product, he just scans and he's able to tell that this is genuine or not. Some of these marks you scan, it is a bottle of water, it brings you a shirt when you scan, you know. So it is a huge issue. Maybe one day I'll come to talk to the Law Society about the menace of counterfeits. The last time I did it was in 2012. I can come back and speak about this subject so that we do not be victims of this menace. I thank you so much. I beg to leave. I have an engagement, but I would like to thank the Radical Nuba, President Semakade. I hope he comes back soon. The Vice President, who has done a good job to sit in, council members, and the rest of the colleagues online and offline. Don't give up. Never ever give up. We are here to stay. You should not leave law practice to go and do other things. It's a noble profession, and the responsibility is on us to take our place and reclaim our value. Thank you so much.
Thank you so much, Council. A round of applause. Council, we are so grateful. We can see where the knowledge from Kevin Nsubuga. I went to law school with him. He's a colleague. He's a very wise man. I can see where the mentorship comes from. We are so grateful. We would like to request that we take a group picture with all the panelists for the day before you leave, so that we can excuse you. In the meantime, let us clap for Council, who has given us some time and the wisdom. Thank you so much. To the front over here. Right, thank you, ladies and gentlemen, for the time that you have spent with us so far. We are still moving forth. We have another agenda item. Without further ado, as council leaves the premises, would like to thank him and pray that God bless his hustle. He is identified as a farmer, as a beauty consultant of lipstick and fakes. Let us be mindful, like he has said, for the ladies and the gentlemen who are buying that lipstick for your spouse or for your partner. Make sure you have your phone and you can scan. So thank you so much, Council. May the Lord bless you as you return. And we shall be able to invite you the next time to handle the menace of counterfeit amidst other things. Thank you so much. Ladies and gentlemen, we would like to delve into the next agenda item. Without further ado, I would like to invite Samantha, who is going to take us through the next introductory steps so as to move to the next issue at hand. Thank you so much.
Good afternoon, everyone. I am Marunga Samantha, and I am going to stand on the protocol observed. Our second topic for the day is AI and legal tech disruptions, challenges, and opportunities for the bar. So this is a brief introduction. The rise of artificial intelligence and digital legal technologies is reshaping the practice of law across the globe. These tools are not just trends, but they are redefining how legal services are delivered. For the Ugandan legal profession, this disruption presents both challenges and opportunities. Issues of data privacy, ethical boundaries, job displacement, but also potential for increased efficiency, access to justice, and client satisfaction. In this session, we will explore how the legal fraternity can proactively adapt, regulate, and innovate in response to these technological shifts. We are honored to be joined by Mr. Galandi Tony Kire, Managing Partner, Diamond Advocates, to guide this session. Mr. Galandi is the Managing Partner, Diamond Advocates, and the Head, Tech, Innovation, and IP Law. He is the founder of Law Tech Associates and Consult, a local tech company behind Legal AI Research, Assistant for Lawyers, and Mtetezi app that links clients with lawyers. He has also previously headed the Land Transaction and Alternative Dispute Resolution Department at the law firm. He is a versatile and distinguished arbitrator and a member of the Chartered Institute of Arbitrators, UK. His expertise in land transactions is undoubted, as this can be evident from the various land issues he has resolved both on private and public land. Ladies and gentlemen, let us welcome Mr. Galandi Tony Kire.
Thank you very much. Correct. I'm very honored to share the same platform with Senior Counsel Mwema, and also very passionate about legal tech in particular. Like earlier on described, we are in an era of disruption. and the generation of my colleague, Council Muema, is not going to face the same challenges like our generation. Professor Sansid, in his book, The Future of Lawyers, he starts with a scenario, and he says that in the 90s, the robbers needed hammers to break into a bank, leave all the footmarks, and the banks became smart by introducing CCTV cameras. So they're able to see who's breaking in. Today, a person robbing the bank does not need to physically enter the bank. He will be in Seychelles, he will be in Panama, and he will hack into the system of the bank and transfer money from your account and transfer it to Japan and wire it from Japan, transfer it to Mauritius and then to probably the Panama Islands. And that's why, in association with the Radical New Bar, this topic is very passionate for me. And when His Excellency, the President, gave me an opportunity to be part of it, I couldn't take a step behind. Ladies and gentlemen, allow me to share with you my experience as a head legal tech at my law firm, and also as a person who has had the opportunity to take some short courses at Stanford University on legal tech, and also attended a number of conferences on the same, including the recent one in Leeds and the recent one in Silicon Valley, Mountain View, California, and the immediate yesterday in Nairobi, Kenya. Ladies and gentlemen, we must brace ourselves for the disruption, whether we like it, whether we don't like it, whether we bury our heads in the sand, whether we put them high, because the disruption has come. And it's not yet to go back. And if we do not adjust to that, trust me, like Kodak, like Nokia, we will disappear. The generation of reading through huge volumes of case loads is long gone. The unfortunate bit is that there is a disjuncture between the two generations. The young lawyer today vis-a-vis the senior counsel today. The senior counsel trained to read in depth Supreme Court decisions, burning the midnight candle, like it's normally said. The young lawyer today says, why the hassle? I can be able to get this data in a split second using AI. That is not the problem. The problem is how are we going to adjust to these disruptions, which we are going to call challenges. And also, what are the opportunities and how are we going to embrace them? I can tell you that our neighbors have moved so fast, and I want to give credit to the president in absentia who foresaw this, and one of his pillars was digital transformation. Our neighbors have moved real quick. I was in Nairobi the other day, and you would find a number of local tech solutions with, solutions customized for African problems. First of all, we must appreciate that legal tech is going to disrupt the traditional ways of our legal practice. And I will take us through a number of ways how it is going to disrupt the same. First of all, you realize that there are these routine legal tech tasks. Okay? Routine tasks. I'll give you a very good example. Contracts. One of the things we do here a lot of time is drafting contracts for sale of land. It's a routine thing. What we do is many times we are just changing the parties and the agreement is remaining the same. Now we must appreciate that today, what is happening is that with the evolution of AI, when you give a lawyer, say, draft for me a contract for a sale of land, he's not going down to that piece to type. No. He's punching in the figures, punching in the parties, and AI is generating a contract. So you are going to realize that the routine tasks that previously needed 20 lawyers are going to need one lawyer. And we must prepare for that. At Diamond Advocates, in conjunction with a local firm here, Law Tech Associates, which I happen to have found, together with another law tech company in Kenya called Ishiria, we have come up with an AI assistant with respect to routine tasks. And these are not going to stop. These are just starting. I was in Silicon Valley and they were estimating that the total number of law tech firms now is over 100,000. Every day, people, the tech world has come like a swarm of bees to the legal profession. And unless we position ourselves in line with the radical new bar, I can tell you the song of lack of jobs is just starting. Today, there is now predictive analysis of case outcome. What's happening is that that client of yours who would come for legal advice or whether or not to file a suit in the comfort of his bed in the near future will be able to punch in his facts, and an algorithm is able to run data based on URI to run data and to give him a prediction and a success percentage of his case. So that means he won't need a lawyer. If he was planning to file a suit, he realizes his success rate is 20%. Why should he come and give you professional fees for advising him on whether or not he has a good case? Why should you charge him that $1,000, that 2 million shillings? That's a job gone. Today, there are lots of virtual legal assistants and chatbots. I was discussing with a colleague in Nairobi, and he was sharing a very interesting story. And he said, during this mandameno is naming for the demonstrations that have been going on in Nairobi. What the leg tech guys did was they developed a chatbot. And this chatbot is able, first of all, to locate and tell you that there are police officers 5 meters from you coming. Is able to locate you that, you know, the tear, you know, gas canisters, you know, the tracker is this side. So that shows you. And then that is not enough. It's also able, using that chatbot, they were able to communicate who has been arrested, which police station, okay, and which rights do they have. So somebody is able to know, oh, they have incarcerated me, they are not supposed to do this, they are not supposed to do this to me. That was work of lawyers. Now they are having chat boxes. So unless we reinvent ourselves, I can tell you that's another challenge. Today, I am very glad that Senior Counsel Mwema brought up the issue of contracts of champati. In other developed jurisdictions, the UK, the US, those of you who have traveled in those places, you'll find billboards, injury lawyer, yeah, divorce lawyer, and all kinds. You won't find that here because our Advocates Act is too rigid. It's too rigid, Mr. President, like Senior Counsel has pointed out. You find that the brokers in a land transaction are charging the seller who is selling land in Kololo 10%. Thank you very much. Oh. You find brokers who are selling land in Kololo, and they are charging 10%, both to the seller and to the buyer. Let's assume this acre of land is going for $2 million US. What's happening? There is a desperate seller, but there is also a buyer with his money who badly wants to dispose this money off for reasons best known to himself. So there are all these kinds of contracts. So the broker is saying, I'm going to get you a buyer, 10%, that's $200,000 that is 730 UGX, million. Then he's also negotiating with the buyer that please give me 5%, I will let you to the land. Probably he's moving out with $100,000. That is 360 million shillings plus 700 and something. That's $1 billion shillings. But then when it comes to lawyers, you are charging a client and the lawyer is saying, you can't charge $1 billion shillings. So, these disruptions, and when they talked about contracts of champati, they must extend the existing laws. We like it or not. And if the laws if we do not bend the laws to align with technology, trust me, technology is going to somersault. Today, I can get on a Uber from here to my office in Nakasero, and who cares? The taxman will not find the Uber guy because the money is going somewhere. The guy controlling the app is in the US. He's not here. So these disruptions are coming in as challenges both to the bar and to the bench and the nation as a whole. And it's our duty as lawyers to align ourselves as fast as yesterday. At Diamond Advocates, like I've said, we have developed a web system in line with 2 local companies, one Low Tech Associates and some Kenyan company called Ishiria. What this does is that we have trained data using URI, Uganda Law Library. Previously, or most cases, when you type something in AI, it is going to give you all junk because it is sourcing information from everywhere. Now, with these customized AI legal assistants, we have restricted it to our jurisdiction. So that today, if you are looking at a principle, say for example, of possession with respect to land matters, when you type in that AI assistant, it is only going to bring for you, say for example, Supreme Court decisions with respect to possession in Uganda's jurisprudence, and to summarize the page and the judge. Now, what does that mean? It means that at Diamond Advocates, where we have like 12 lawyers, in the next near future, we will not need 12 lawyers because the AI legal assistant is able to do this research for me. That's the unfortunate bit of it. That is the challenge for the lawyer. However, we have also developed an application which we are calling Mutetezi. Mutetezi is a Kiswahili word for defender, pleader, lawyer. So much similar to what my brother Isiko and the president have here called pleader. Or the difference here is that ours is commercial. That takes us how do we find solutions for the disruptions that are coming with the technology? You have a web-based system that has taken away in-house counsel that were 20 to 1. Where have done the 19 gone? They have gone to the street because the company is no longer needing 20 lawyers to research. So how do we find now a solution? And that's where the opportunities come in. How do we now find a solution for that lawyer who has now lost a job because the company has decided to buy a system from Diamond Advocates that is able to help it with customized research for their pleadings? And that's where the Mtetezi app comes in. This application we have developed links the lawyer to the client. How does it do it? Many of you, like all of us, have used all these applications, Uber, Safe Border. So the application works in such a manner that once the client puts on that app, and we equally have the lawyer in the same jurisdiction, the same nearby place active, he'll be able to see that there is this lawyer called Isiko Arthur. He is 500 meters from me, and his area of specialization is land. And they have a problem with the land matter. So through the app, you'll be able to call Isiko for legal advice. The advantage here is that Isiko is making money. As Diamond Advocates, we are making money. And the client is finding a solution. How and why? Because there will be a fee that is going to be charged when this client places that call to Isiko. That money will be automatically deducted on the client's mobile money. Automatically. A percentage goes to Isiko. A percentage goes to probably the aggregator, which is MTN or Airtel. And a percentage goes to the firm, which is owning the app. That is one of the ways we are going to utilize technology as an opportunity to create jobs for the young lawyer today. So that young lawyer who is not in a firm As long as he has a practicing certificate, we have developed the system in such a manner that it will be, for the lawyer to be uploaded, number one, you must have a practicing certificate. Must be an advocate of the High Court of Uganda. Number two, you must be subscribed to our beautiful society, Uganda Law Society. You must be a member, and an active one for this matter. Because those are the requirements when you are registering. So, you are protecting the client from unscrupulous lawyers. You are bringing the unlawyered community. We keep crying every day, saying, the jobs, the lawyers are too many. I do not want to believe the lawyers are too many. We cannot say the lawyers are too many when we are having 40, 50 million Ugandans. And out of these 40, 50 million Ugandans, the lawyered community is less than 20%. 20% of Ugandans seek legal advisors. And you know why the 80% doesn't seek? One, because they think the lawyers are expensive. It's a perception. Two, the lawyers are inaccessible. Look at a person who is in Katakwi. All the lawyers want to be in Kampala because Kampala feels nice. But there are people in Katakwi who need legal services. So this app is able to help that client in Katakwi and that lawyer in his bedroom in Katakwi to offer legal advice and making money. But that is only going to work when we move away from the ambit of the archaic laws. I love our president, Isaac Semakade, because this is his school of thought. He believes that we should move away from archaic laws because other jurisdictions have moved on. Once we have a lot of the unlawyered community brought to the fore, I can tell you there are lots of people facing challenges, and this technology, this disruption is not only taking away jobs for lawyers, it is going to create jobs for lawyers. Many times, you'll find my friend there married to this very rich man. She does not have enough legal education per se. She's under key and lock in the house. And she would want to move away. But her only problem is, I do not know whether I will go with my children. So she's facing all this domestic violence, and the only reason she has not left is because she fears that if she left, the guy is too rich. She will not be able to carry away her only possession she now looks at in life. That's her 7-year, her 3-year child. That forms part of the unlawyered community. She does not leave the house. Everything is in the house. There is an askari, but she needs a lawyer. With applications of this nature, she can be able to make that call. She can be able to anonymize herself and talk to a lawyer. And here is the magic for the young lawyer, is that when she is making this call, let us take an average figure, just a random figure, nothing to lock on it. Say supposing that initial call costs 20,000 or 10,000 shillings. And let's say half of that money goes to the lawyer who is giving legal advice, irrespective of whether the lawyer is going to sign up this client or not. And then we say each other extra minute is, say, for example, going to be 1,000 shillings. What does that mean? That if this person talks for 10 minutes, that's another 10,000. If the person talks for 20 minutes, that's another 10,000. That is 30,000, correct? And she has been able to get legal advice at a cost of 30,000 shillings. The lawyer has made 15,000 shillings by simply offering legal advice on call. If that's such a lawyer in a day received an average of only 10 calls, that's 150,000 shillings. If we run that into a month, If you are doing 150 per day, 10 days, that's 1.5. A month, that is 4.5. We will be improving the remuneration of lawyers intuitively, without necessarily leaving the comfort of their seats. This is our generation, ladies and gentlemen. And I am very glad that this house is mainly having the young lawyer. The young lawyer today must adapt. The young lawyer today must remove the jacket of previous old counsel and realize that we are in a new generation. And that generation is not going back. Today, one of the areas where there is the opportunity for the bar is data. All these companies you see coming around are looking for data. I'm glad there is a recent decision on data. And, complaint with data protection saying, you must register here. We have the biggest legal tech companies that are trading in data. Rnblive and Something Creators, they're the biggest. And you know what they do? It's simple. Come to Uganda, get our free data of Uganda Law Library, aggregate that data, okay? Process that data into their web systems so that that lawyer in the US does not need to come here and hire you to represent his client. No. He will draft his pleadings, he will come and get his temporary practicing certificate, and tomorrow he will be in court arguing the Ugandan law better than you. Why? Because all he does is subscribe to Rnblive or Something Creators so that they are able to give him this data of all the case laws and the precedents, and he runs in the system. And the system will be able to draft for him pleadings that are customized for our jurisdiction. And for you who is still analog, you are reading 2-3 cases, the guy is running this thing against, 50, 100 cases. So the opportunity is there. The people who are developing these legal tech solutions are non-lawyers. So this is the time for the young lawyer to align. This is the time for a young lawyer to move and see if we can take some of these lessons. And I am really very happy. Big up to the president, Mr. Isaac Semakade. I'm so happy and very excited about the Tech Festival. And it is something all of us should be excited about. And I'll tell you why. Because this festival coming is practical. I have had the opportunity to peep through the program, and I'm really very excited. Because unlike our usual annual law conferences, where we come and talk the usual things we talk year in, year out. Year in, year out. Banking law, land law, usual stuff, which we find in the usual jurisprudences every day. This time around, the radical new bar, I says, no, let us align with the changes in the legal world. There should be a reason now for a lawyer in Katakwi to get on that bus to come to Munyonyo to attend the Tech Festival so that he or she experiences practically how technology is going to impact on him. So that if he's trying to do a virtual call, he's able to see that, oh, this storm has come. If he's trying to test out a legal assistant platform, he's able to punch in and he's able to get pleadings and they are watertight, and he says, yes, I think I need to align. Gentlemen, the society has been very helpful to us, that it is the radical new bird this time round. Big up to you, because you have done the unusual. The other opportunities we need to look at for the bar with these disruptions in AI is increased efficiency and cost reduction. You know, now small law firms can be able to compete with the large law firms, irrespective of the financial muscle. And I'll tell you how and why. Because now we are all going tech. We are all going tech. So if it is pleadings, we are going to use the same tools. We are going to come with pleadings and polish them and meet at the center. So it does not matter whether for you are employing 50 lawyers, that small law firm having 2 lawyers, as long as it is tech savvy, trust me, we are going to ride the same road. So that is an opportunity, but that's an opportunity that's going to come if we align ourselves. Let us use these gadgets for the good use. The young lawyer must move away from TikToking, but now shift from to using these apps to enrich himself. These AI legal aid platforms today, which is opportunity for the bar, are now assisting the underserved population. I've just been talking about PuliDAO. You realize the radical new bar is able to offer services to a person deep in Kisoro using PuliDAO, that app. So anybody logged on and feels, I think I need to be humane today. It's my lucky day. I need to help somebody. He does not need to move from here to Kampala. He will be able to find somebody online who needs legal advice. And as long as he's an advocate, he's able to do this pro bono. I can tell you what we are seeing today, the pro bono week. I can tell you future to come. The radical new bar, if it continues with this kind of transformation, the radical new bar is going to move digital. You are no longer going to have us having to move and shut offices to go for barazas and sitting prisoners one on what? On one. The technology is changing and we must align. We are lagging behind because other jurisdictions have moved. The other opportunity we need to look at is with these kind of solutions now, the complaints council does not pick calls. I do not know what's happening. I have visited some law firms across the road sometimes, and you find files up to here, and the counsel is in the middle. The client comes in, says, counsel, njagadde kwetegereza tutuuseewa. And the counsel clearly has no idea. It does not even remember the file, does not even remember the fellow. And the first question, kumbo msango gugwali kuchi? Then you see counsel is busy digging out. This file says, ndoze everyone. Digs out and says, Sam, so come checking a keyo mugundi. Mu registry. Now with these technologies now, we should be in position to be able to share the progress of these matters with our clients. The AI systems that have been developed, they have portals where the client does not even need to come to your office. He has logins on his account. He is able to see that the next mentioned date is 12th of August. He is able to see that actually there is a quote what? Vacation. So these technologies, if we embrace them, are going to avoid the stress. You have no idea. Those who are in litigation, when you have had a bad day and you are having all your phone buzzing because there is the particular client who gave you $1 million shillings yesterday and he wants to know, cancel to Tosewa. So, just like I said, these opportunities come with challenges. And one of the challenges is accountability. I was giving you an example of the app Diamond Advocates has created. Supposing Sam, a non-advocate, enrolls onto this app and is giving Juliet legal advice, the presumption of Juliet is that Sam is an advocate. And the advice is giving Juliet clearly is not that of a lawyer. Says, are they trespassing on land? Ajambia yeramula kwifune panga. So, accountability, where does the liability fall? That's the challenge. So that means that even these tech tools, the human brain must be behind them. There must be that person who is going to, one, verify with law counsel whether Sam has actually practiced certificate, verify with the Uganda Law Society whether Sam is actually their member, so that there is traceability. Yeah? There must be these agreements that are signed up by the client before downloading the app or in the app, that all liability shall not fall to the legal tech company, but it shall fall to the lawyer in his or her individual capacity by virtue of the fact that he is an advocate of the High Court of Uganda. This is also going to create another business. The insurance companies, because now we are dealing with somebody I don't know. One of the things I would be cautious to check is if you actually have professional indemnity. Supposing your advice throws me down the bridge, I need to have something to hang on. So you'll find now jobs will be created in that way, because insurance companies now, people will have to get professional indemnity. So we should not look at technology as only a challenge, but as an opportunity. I have talked about job displacement and changing legal roles. That one I won't repeat. Routine works are going to reduce, and they are actually reducing today. The only difference is we need to customize these solutions to our problems. Because some of this AI you are using are giving you solutions for the US, for the UK. I've always had to talk to my colleagues in the firm that if I give you an assignment, draft for me a document, and the AI has helped you, be fair enough to own up the document and customize it to our local setting. But now with these systems, with the improvement in technology, you won't need that. The AI is going to customize it. So that is going to call for job displacement and changing legal roles. In other jurisdictions, particularly the US, Georgetown University, they have a program, it's called Ion Tech Lawyer. And one of the things which excited me about that program is they are using this data to make predictions on judgments. They run it, and they're able to predict this is what the judgment is going to be. And they subject it to the judges, and the judgment comes as AI has predicted. So there is predictability. What does that mean? Is that the lawyer must align himself to these tools over time to enhance proper delivery. The other challenge we look at is the legislation and adoption barriers. Today we are here excited about Mtetezi app. tomorrow, you are likely to find resistance from some lawyers saying, okay, who is regulating the billing? What does the Advocates Renumeration Act say? So all these move hand in hand with the policy and changes in sometimes the laws and so on. But most importantly, we must align because that's where we are going. The other challenge is lack of digital literacy. World over, as long as you have a solution for something, there is no reason to look for a challenge. Way back, we had the copy typists typing. The lawyers preferred to write their pleadings and give somebody to type. Today, you need to be literate. So we must take on these short courses as young lawyers. In AI, it is going to be very, very important and key. The other issue is the issue of ethical guidelines, more especially with respect to data. That's a challenge because Mutete's app is collecting data on client B. He's taking his date of birth, he's taking where the fellow stays, because the moment that client comes on app, that means for him to know who is nearby, the GPS must be on. How is this data collected? And I love the recent judgment, which says for you to collect data here, we need you to be registered because you are collecting a lot of data for Ugandans. You know where they sleep, you know where they stay, and then all this data is under your control. So that's also one of the challenges of AI we are likely to find as the bar. The other is existing policies. You will realize that you, the lawyers, have left the development of policies regulating AI to non-lawyers. There are people who do their masters in policy. My friend here from the University of East London says, I'm a policy analyst. But I'm glad he's here. But how many policy analysts have a legal background? But this AI that is coming, the laws, the policies that are going to be developed are going to affect us, the lawyers, tomorrow. So my plea and also pleasure with the radical new bar is that sessions of this nature awaken us to align ourselves. We should be interested. It does not matter whether it is AI in health, whether it is AI in tax. We should be interested. How are these policies developed? Because tomorrow we are the ones going to argue these policies when they, when there is they're in conflict with the law. Ladies and gentlemen, I would pray that as the society, as the radical new bar, we be intentional in bringing these legal tech firms near us. That will help us be part and parcel of their development. Because these are tech geeks. For them, they don't know the law. Their work is to punch these things and leave them for you. It is us to guide them and say, look, we would want systems that work this way. As I wind up, AI and legal tech are inevitable disruptors.
Recording in progress.
In the legal profession. While they threaten traditional practices, they also offer unprecedented opportunities for efficiency, access to justice, and new legal services. The Uganda Law Society must take a proactive role in guiding the bar through this transition, ensuring ethical adoption, continuous learning, and regulatory preparedness. By embracing AI responsibly, Ugandan lawyers can future-proof their practice and enhance the rule of law in the digital age. Ladies and gentlemen, thank you very much for listening to me, and I pray for a bar that will align with the technology. And that is also a wind up. I want to encourage all of us on the 14th and 15th to come and experience what the Radical New Bars prepared for us, the Tech Fest Festival, be able to get an opportunity to interact practically with a number of these legatech firms, be able to hear from speakers with rich experience in AI. I beg to submit. Thank you very much.
Thank you, Mr. Galandi. We are very, very grateful for this opportunity to share with us the wisdom within your purview and the fact that you are overly excited about the idea leaves the lawyers with so much to do, and also the fact that you are already pushing at a very, very high speed. Diamond Advocates is very welcome, Mr. Treasurer, for you to know Mr. Galandi is already in partnership with the Uganda Law Society. He has been very, very supportive towards the Tech Fest, which he has already, I think, advertised more than would have been necessary from him. He is now a spokesperson. Thank you so much. You are seated next to the bank of the governor, so please talk to him well. But thank you so much for advertising the Tech Fest, which, ladies and gentlemen, is on the 14th to 15th of August. And we would like to rally all of us to attend that activity. It's a very key activity because it is supposed to be a disruption from the common ALC to the Tech Fest. So we are excited about it. The Uganda Law Society is overly excited about it. We would like for you to share in the excitement so as to appreciate the new AI legal tech activities that are going on. So we would also like to appreciate your presentation, the 4Ds. You're putting into practice the 4Ds. We can see you are a very ardent follower of the Radical New Bar. You're not new to us. We already appreciate you. Digital transformation is what you're helping us to appreciate as we decolonize our minds from the old of having to read a lot of papers to being technology, very, very technology based. So we have some questions, Mr. Galandi, and I know there are some that are in here. We would like to use this opportunity to subject you to some questions so as to help some people understand better what maybe they haven't understood in your presentation. Miss Atim Mildred is very, very much with us today. We thank you, Miss Atim, for being with us. We appreciate your following. She thanks you, says thank you, Council. However, I reiterate the question I had earlier posed to Mr. Muwema. From your discussion about AI, it's clear that the problem of unemployment is only going to get worse. What is your say about limiting the number of lawyers in practice? It's a very critical question, of course, that I know you have an answer to. If you don't mind, you can write them down if you can still master them. Like the AI, are you a robot also? Like the Vice President? Okay, that was Mildred. Thank you, Mildred. Then Miss Hope Atuhaire is asking, is Mutetezi on the App Store or the Android platform? That's one. She also goes ahead and says, telemedicine can be replicated in the legal profession. I hope you can first take that. You give your minds on that, the microphone, before you can be activated. Then we can get others.
Thank you very much. First of all, I beg to differ that the lawyers are too many for this profession. My submission is that the lawyers are actually too few for this profession. And there should be no reason why there should be gatekeeping to how many lawyers are coming. It's only that we, as the bar, we as the nation have not embraced technology to create jobs for lawyers. Over 80% of Ugandans fall under the unlawyered population. So if 20% is able to satisfy the current, what would it be if we had efforts of moving the 80% into the lawyered community? Like I said, look at this young lady in Mulanda, deep in Tororo. The nearest law firm is most likely going to be found in Tororo, 40, 30 kilometers from where he or he is. But he wants some advice, legal advice, on how he can resolve a land matter near him. All he needs is legal advice, and he's willing to pay that 50,000, by the way. But because we have not embraced this technology, he remains under the unlawyered what? Community. Because we have stuck to the archaic laws of contracts of champate, like my senior colleague submitted, we are focusing on more, you can't charge beyond this, you can't charge beyond that. So to answer your question, the lawyers we have are actually not enough. All we need is to embrace technology and bring the unlawyered community to the lawyered community. The next question I think came from Hope. That one was from Mildred. And her question, if you can repeat it for me, I don't want to have that photogrammatic memory. And yep. Thank you. Thank you.
He also adds to say, telemedicine can be replicated in the legal profession. That maybe is for you to give your opinion on how we can replicate this in our profession.
Thank you very much. Mutetezi is in the pilot stage now. We intend to load it on the two platforms, the iOS and the Android system, by end of month. For now, we are running it as a pilot to see its efficiency. We are still running it as a pilot to link with the verification. Still at its primary stage. We hope at the end of the month, we really want it to get on these platforms when we have been able to protect both the lawyer and the client. Thank you very much.
So much. Just as Okello is pulling the move that I pulled earlier on to say, you're telling us colleagues money will come, but he's asking, why do you tell money will come, and how can young lawyers align themselves with Mr. Galandi? I want to paraphrase it to mean, how can the young lawyers get aligned to what you've just been explaining? Where are the opportunities, and how can they get closer to the opportunities?
Thank you very much. For now, we are running a pilot project, pro bono. You can be able to, as long as you are a practicing advocate, you can be able to volunteer with us as we run this pilot. We want, by the time we are rolling it out, it is watertight. It is, our cybersecurity team is subjecting it to attacks. You don't want tomorrow you have all this data about Hope, and it is out there because you can't protect it. So for now, the opportunities are available at Diamond Advocates, volunteer opportunities, if you can be able to log on the app so that once we register in, we are running that pilot. You see how you can actually be discovered by the lawyer the client next door. And we have also, signed an MOU with so far 3 firms around East Africa. We have signed with a firm in Kenya. We have signed with a firm in Tanzania. This week we are signing up with the firm in Rwanda. We want to see how we can be able to roll throughout East Africa. And we are also subjecting it to heavy data when it comes, say, for example, to the AI legal research assistant. With this tool is about how much data you subject it to. So for now, we are subjecting them to the URI reports and running them. We are subjecting them to East African law reports and Kenya law reports. When it comes to the Mtetezi app, that one, once it is up and running, you will be able to make money seated at a coffee shop sipping that nice coffee, because that call will come through. There are so many people who have problems and they only have 100,000, and they are willing to spend that 100,000 to find a legal solution, but they are not willing to go to Asa Isiko's chambers and use border of 10,000 coming, 10 going, and then also Arthur says first pay file opening fees of 100,000. Then he listens to you and bills you. So we are making the profession a little bit liberal, and that's a disruption. It is creating jobs for the lawyer, but Isiko may not be very happy, because that client who would walk in can now get the young lawyer on the app. Thank you.
Okay. Thank you so much. Uncle Tony, you've now become an uncle. The knowledge you give us makes you an elder to us. Thank you so much, ladies and gentlemen. Those that are online, those that are physically present, we have a question here. Please come forth. We're going to take 2 more questions so that we can come to the end. We can hear from the council member so as to wind up with the day.
Yeah. This is to thank you very much. My name is Mugisha Ronald Kagundu. I'm a student. I'm going to be enrolling for the BACOS. But the area that you're speaking about, I've been doing so much research about it because it's connected with competition law at some point, though it's data-based. My comment comes about with the system that we have been following for the 4 years. I think you're in such a strategic position to spearhead AI as a subject in bachelors of law. Because if you're going to come together as East African community, whatever that is happening here, Kenya is the tech hub of East Africa. As everything that you've been talking about, Kenya has already been doing that. And then another thing I would also want to talk about, AI has so many types. Yes. And something that really caught that you've not spoken about. Every app that you've been talking about is English based. We are looking at issues that are disturbing our locals. And when I'm going by, I'm going to talk to my judge guy. I'm going to speak Luganda. You get? So I would want to give my grandfather a URI report of Luganda. And then he reads it, is like, because literally I go to church every day and I get to see Lunyankole Bibles, Luganda Bibles. People, I think English is disturbing our people. Yes, for us, there's a way we melt it down. But when it goes to those people at grassroots level, because this is a very hot topic, it's going to take off in about 6 years time to come. But I would like to thank you very much, and yeah, I'm glad to be here.
Thank you so much, Mr. Mugisha. He's a student. He's one of the young lawyers we are talking about, but you can see how much wealth of knowledge he has within this little time, and therefore you should know that you have some followers. Thank you. Could you take that? Okay, one more question, and then you can.
Up this, then. Thank you very much, Mugisha. He has asked about the language. We are working hand in hand with a number of language model experts. For now, we can be able to, it is able to run in Luganda and Kiswahili. We are very optimistic that as we keep getting better, we should be able to have it run on all the local languages, because it's just an algorithm that when you are speaking, the algorithm is able to translate. Now that comes with the training of the data. So it's still work in progress, but so far the Kiswahili and Luganda are not bad. Thank you.
Thank you so much. Mugisha. Thank you. Permission denied. Yes, Shamil? The last question, and then we can get into the next agenda item. Thank you.
Hello. As always, I'm the citizen, and I'm here to keep everyone accountable. I mean, it is for me, the citizen, for whom you are all accountable for and who you all work. Now, thank you for AI. I've just released my results for Wageningen University. I passed. I'll be finishing my master's, graduating in December. Obugaro for me. So it's council. While studying at the university, we had an own internal law app which we use, and it's garbage in, garbage
out.
Whatever we're going, and you had here, though you conveniently dodged talk about bias. It was there on your slide, but you tactfully dodged talking about bias. You know that the information you put in the AI is the information you get out. Now, with our application that we're using, you could predict the outcome of the case based on either the legal information and the judge in personal conduct. For example, with our app, let's say you could put an injunction for Uganda Law Society, and the app will ask you, who is the judge, who is the same facts. You put Justice Sekana, it will write for you the ruling he's likely to give. And truth to say, it will come. Same facts, put a different judge, you get a different ruling. It will even ask you what is the season. Are we going for a political season? Are we going for... You put in the judge, you put in the case, same thing. So, and I want to report myself to you. I have also been using or abusing the app because I work with some lawyers, and when we are handling cases, for example, like the rape cases, we have some friendly judges on rape cases whereby you'd want your case to go to that judge because you like to get a favorable outcome, or unless if your client is convicted, justice so-and-so will give me 10 years, as compared to justice so-and-so, for her she's had, she'll give 25 years. So what safeguards do you have to prevent abuse of the AI system and bias from characters like lawyers like me, from using it for our advantage? Because as we talked about lawyers bidding, for example, I know with a specific judge I'm going to lose at High Court, but on appeal I'll win. But because I want to bill the client, I mean, it's a case is going to give me money, I file the pleadings, very well knowing justice so-and-so is going to give me a bad ruling. I will appeal it, because I've done it before, and I get a favorable ruling at the Court of Appeal. Again, I've done it before, knowing that that is going to be the outcome, because I want to extremely bill my client. So what safeguards do you have to stop people like me from misusing that data for earning? Because we are all here, as lawyers, I think we're all here to earn. Thank you.
Thank you very much, Shamil. One of the challenges I pointed out in my presentation was actually the bias of the AI tools. And this is going to be mainly by the user. And I'll tell you how and why. The system, for example, for us we have developed is a Lego AI research assistant. And to reduce divergence, we have trained it on data that is of the final appellate court, so that the issue of whether it goes to judge so-and-so, judge so-and-so in one way or another is watered down. Because if you are looking at a panel of 9 judges, the decision is likely to be very different if you are writing, if you're running data using particular 1 or 2 judges. So that kind of reduces the bias because you are looking at training data mainly using either Court of Appeal decisions or Supreme Court decisions, ideally not a judge sitting as an individual. Whether or not this bias can be completely wiped out, it depends on the system you're going to develop. And that's why I am a strong critique of adopting Lego apps that have not been customized for our problems. We need locally tailored solutions for our local problems. Because if you are going to look at our local problems, then we need to subject them to our local data. The problem with most of the apps, including probably the one you are using now, is that it's not a local app. It has been it has been trained on big volume data, which is a cocktail of data. So you find such a platform, it will be able to give you results. You can even customize it to Uganda, but then you are not controlling the data it is using to train. I hope I have been able to give a relatively fair answer, considering that the word bias is subjective. Thank you.
Most obliged. Thank you so much. Could we please give him a round of applause? We are overly grateful, very appreciative, and it's my singular honor to appreciate your time with us, the wisdom that you've shared, and we look forward for further interaction. Thank you once again. God bless you. Thank you, ladies and gentlemen. We are coming to the close of this function. We want to thank those physically present, Secretariat in the house, those who are watching us online. Thank you so much once again for your time. We would like to very fast run into the next agenda item. We're going to invite the council member in representation of the Northern Region, who in turn is going to help us to also welcome the treasurer of the Ugandan Law Society with his closing remarks. Thank you so much, ladies and gentlemen. Council Omiat Emmanuel. Thank you.
Thank you very much, our moderator. Let's give a big hand clap and thank him. I think he has done a good job. Some good hand clap, please. Yeah, indeed, he deserves it. Our guest, who is still with us, and council member, colleagues, both who are here and online, ladies and gentlemen. It has been a very wonderful day. I believe we have gained so much from the very well presented discussions and speeches that we have had today. And as council member, Northern Uganda, I'm very, very proud and very humble and delighted to have traveled that journey all the way over 400 kilometers to be here. It was worth it. And without wasting time, first of all, I want us to thank our speakers who did a very good job. Uncle who has left us. Let's give a big hand clap and thank him. Indeed, he did justice to the question of our fees. It is a very, very serious issue. We have been invaded compared to other professions. I think we are lagging behind. And like he quoted that Mexican quote, that the man who does not fight for what he wants does not deserve what he is. I would put it that the lawyer who does not fight for what he wants does not deserve what he desires. Indeed, he made a very crucial statement that as lawyers we are very timid. I think that was a very correct observation. It is high time as lawyers that we wake up from our slumber. Let's fight for our rights. There is no better time than now, especially after this very wonderful submission from Uncle Moema. In a very special way, I also want us to give a big hand clap and thank our speaker, Galandi Tony, who has given us so much about AI and legal tech. Of course, not business as usual. We need to, these are things that are no longer what we are just going to be hearing. It is real. It's here with us. And so the faster we get on board, the better. So thank you very much, Council, for sparing your valuable time coming to talk to us about this. And I believe on the 18th, we are all can't wait for the 14th day of August, 14th to 15th, to participate in the Tech Fest. And so, colleagues, I wouldn't want to spend so much time talking again, especially after hearing all these very wonderful discussions. But I think this discussion should go on. We should keep engaging one another in the best interest of protecting our profession and shaping the future, especially for the young lawyers. I see from the questions, it seems the young lawyers are so much worried about the future. But I want to believe that the future is bright. We just need to do the right thing. And I believe as a profession, we shall come out victorious. We shall succeed. Ladies and gentlemen, without wasting time, it's my singular honor to welcome our governor, who is going to, on behalf of council, to give a vote of thanks and make a few remarks. Ladies and gentlemen, let's put our hands together and welcome the governor.
Good afternoon, everyone. Let me begin by thanking Council Member Mr. Egaru. Mr. Egaru, thank you so much for sparing time to join us for this historical moment. It's not always that Mr. Egaru joins us for such events, given the fact that, like he has said, he has to travel almost 400 kilometers to join us. But at this wonderful occasion, at least he has spare time. Let's clap for him for that, dear members. So I'll also thank each and everyone that has stand up for today's function. I always tell people that it's not for granted that people turn up for Rnblive, but it is for the conviction that they always have. It is for the need of change that they always yearn for. And every time I see members in this room, I understand that these are the members that are not seated on their rights. These are the members that are taking the step to ensure that the change that we talk about, in fact, does happen. So thank you so much, the members who are present here physically and those who are online. I believe there are so many members who are online that always follow whatever happens. I would also like to thank the panelists of today, now led by my brother, Mr. Tony. I've interacted with Tony quite a number of times, but what I can assure you that Mr. Tony is one of the fewest legal brains that we have that oozes with a lot of knowledge concerning legal, technical, and technological information. When you want information concerning AI, digital law, I want to assure you that currently the best mind in town is Mr. Tony. And I know he has really invested a lot of time. When I have interactions with him, he tells me of how he has gone out of his way to study as many courses as possible so that he can give the best knowledge. And that is why we as Uganda Law Society, we are proud to partner with him for the Tech Fest that we shall be having on the 14th and 15th of August. Of course, I would also like to thank, as the Radical Nuba, we don't take this for granted, sparing time. You know, being a panelist takes preparation. For those who do not understand, it takes preparation of these people to come and give you information. You might see someone talking for 1 hour or 30 minutes, but the time he has spent to prepare is always massive. So, as the we thank Mr. Fred Mwema for that presentation concerning remuneration. When I was talking with my friends in Kenya, in particular the president of the East Africa Law Society, Mr. Ramadan, he came up with a phrase that I would like to share with us today. And the phrase was something that he coiled from the biblical phrase that we normally make, that may the Lord be with you, and then normally people reply, be with you too. So that phrase was called the other way around. And he says, may fees be with you. And of course, as a lawyer, you say, and also. So I am going to greet that to you in emphasizing the point of remuneration, that may fees be with you. Yeah, so remuneration has always been a cornerstone of the legal profession. I want to assure you that when I had a discussion with the head criminal division and other members of the bench on criminal division, the issue that was brought out was the issue of remuneration of advocates, especially advocates who are on state brief. For those who do not understand issues concerning state brief, these are private lawyers who offer themselves to give legal services to people who are vulnerable, like prisoners, etc., name it, especially people who are in prison. And it is normally a project that is funded by government. I think the lowest they pay is 400,000 per case. One of the issues that was brought forward by the advocates was that this remuneration does not tally with the effort that lawyers put in. As you all know, these criminal cases, minimum, it takes a year. If you are lucky and you hand the case, it might take you a year to finish. from plea taking up to the final decision. Of course, there are those shortcuts you always take, plea bargain, ADR, etc. But assuming you're going the normal procedure, minimum it will take you a year. So the lawyers were saying that the remuneration tallied to what they do is small. And that is the same issue that we have always re-echoed with the Chief Justice, since he's the head of the judiciary, that the remuneration of lawyers who are doing state briefs should be reconsidered. Worst case scenario, they should tally with the advocate remuneration rules that we have. They should tally because that is the standard that we have set. Anything that is below that is actually very, very unfair to the lawyers. So, as a Uganda Law Society, I want to assure, I know Mr. Mwema is off physically, but he follows. As a Uganda Law Society, we are going to ensure that we re-echo the petition that he filed, that he forwarded with the Uganda Law Society. And in fact, by next week, we shall share accountability for echoing the proposals that were put in his petition. We shall share the same with the Speaker of the Parliament of Uganda, so that whatever is echoed in that petition can really be debated, and if there are any amendments, such amendments be made. Because we believe whatever is contained in that petition is not only for the benefit of Mwema as a citizen, but for the entire bar, for the entire national bar. And that is where I always tell lawyers that sometimes we talk about influencing policy. You talk about policy A, policy B, such policies are unfair, but when the opportunity shows up, like it has shown up, 2026, we are having elections. But it's unfortunate that lawyers are not taking up these positions. Don't look down on yourself that you're still young. I always tell the young people that this is the time to strike. If you wait when you're old, when you can't run, when you can't see clearly, I can assure you, you are making a wrong move. This is the right time as advocates to strike. Pick the ticket, any party that you want. Pick the ticket, offer yourself, and then you will be in a position to influence policy. Because we are always saying we want to take the petition to Parliament, etc. But at the end of the day, it is the people that are in Parliament that are supposed to cause these changes. So, as we advocates, this is the time for us to engage in those electoral processes so that we cause change. Don't sit back. Don't say that I'm young. That is why, when you look at the Constitution of the Republic of Uganda, they were very clear that a person who is above 18 years can contest to become the president of Uganda. Think about it. If you're above 18 years of age, you can contest to become the president of Uganda. If you have your senior 6 degree, your senior 6 certificate, you can contest to become the president of Uganda. Think about it. They didn't say that you must be 40 years, 60 years, 70 years, that you need to have a master's degree, a PhD, etc. Let's flood those gates with our offers. Let's offer ourselves. And by doing so, we shall cause that change that we always talk about. And that is why, as the Radical New Bar in this week, we have decided to offer sensitization. Sensitization, pro bono services. For the entire week, as Uganda Law Society, we are offering pro bono services. Personally, I was in the trenches of Nansana That is where I was. Those who saw I was in the trenches with my people, telling them that Article 39 of the Constitution of the Republic of Uganda assures every citizen of a right to a clean and healthy environment. You can only think well if you live in a healthy environment. And by healthy environment, I do not mean that we should stay in Kololo, we should stay in those 5-star hotels. Even where you stay, as long as you have a clean and healthy environment, I can assure you, you will come out and you will be able to be of great importance to this society. Our foot soldiers have been in the markets. The lawyers have been in the markets. Our pro bono team, led by our top gun, Miss Mariam Nansukusa, they have been in the markets. In fact, right now, they are also in the markets. We have been in the prisons. We have been at TV stations, radio stations. But all we are trying to do is to sensitize the public. We are trying to open people's minds. Where I come from, people couldn't even distinguish between a criminal and a civil case. That is how bad the situation is. And that is what we talk about when you say access to justice. Article 3, Section 3, of the Uganda Law Society Act. The core objective, the core mandate of Uganda Law Society is to ensure that the rule of law prevails and there is access to justice. In fact, we are really perturbed as Uganda Law Society when we always hear statements from HE, the President of Uganda, concerning the issue of bail. That criminals should not be granted the right to bail. I think this is a situation where we are going to engage the President. And we emphasize the issue of bail. You see, the law says that everyone is presumed innocent until that person is proven guilty. So the challenge is that once someone is charged with an offense, people assume that this person has been convicted, this person is a wrongful element. And that is where we are going wrong. I understand there are people who have done criminal actions, and indeed, on the face of it, prima facie, these people, you can condemn them, but we as lawyers, we should be different. We as lawyers should be able to understand and apply these principles, mutatis mutandis, with necessary modifications. And we as Uganda Law Society, we shall engage His Excellency the President of Uganda, and we shall stress that point. Because in one way or another, it is also affecting the independence of the judiciary. I believe you can agree with me. This is affecting the independence of the judiciary. Because if HE is saying that I am not going to tolerate judicial officers, I am not going to tolerate judicial officers who give criminals bail. That means a timid judicial officer is not going to grant you bail. A timid judicial officer will never grant you bail. Even when all the ingredients are proved. We have had that situation where a judicial officer, even after all grounds were proved, decided not to grant bail. Now those are the seeds of such statements. And as Uganda Law Society, we are saying, let's apply the law. Because I want to assure you, today, you may not have any charge against you, but tomorrow they might charge you. Tomorrow they might charge you. And the only thing that can save you is the law. And that is why we always talk about the rule of law. I don't want to stress that point so much, but it is very hurting when I talk with my friends in the judiciary, when I was with them at the mass of our fallen comrade, Judge of the Supreme Court, Kanyehamba. They were stressing it. Judicial interference. There should never be judicial interference. Going to the issue of AI and digital transformation. You know, when you talk about digital transformation, you can't understand it until I try to involve you or drag your mind into the issue of the president of Uganda Law Society. The president of Uganda Law Society, Isaac Semakadde, was a free human being. He could flourish around. He could make his comments like any other human being until that day when there was an order that he should be behind bars for 2 years. Think about it. As you're going out of this place, someone sends you a WhatsApp, or you're on Twitter, you're seeing a ruling saying, please, this person should be arrested and taken to jail for 2 years. That is the situation that our president has been living in ever since that order came out. It is very unfortunate that our president is in exile. The president of Uganda Law Society is in exile. For those who do not know what exile means, His Excellency the President of Uganda, H.E. Yoweri Kaguta Museveni, was in exile. And that is what the president always says, that when he sees people, you know, the president of Uganda was a professional. He was a professional not until he was put in a corner. And that is the same corner that the president of Uganda Law Society is in right now. He's in exile. Even when his mentor, Justice of the Supreme Court, Kanyehamba, passed away, he is unable to partake in the last funeral rites to escort him to his resting place. When such activities, good activities like Tech Fest happen, he is unable to attend. When pro bono services, pro bono week comes in, the president of Uganda Law Society is unable to partake. It is so bad. And we have always told the judiciary that we all derive our mandate from Uganda Law Society. There is no single judge that came out of law school and became a judge instantly. They all passed through the house of blessing, the house of power, Uganda Law Society. And they always go wherever they go and they serve. So we shouldn't put our own house on fire. The leader that represents more than 6,000 members of the bar. Currently we stand at 6,000 members of the bar. And every year, minimum 800 advocates, minimum, join Uganda Law Society. So, exiling the president is like cutting off someone's head. That should never happen, and it should be changed. But the beauty is that with the digital transformation, we can cut short of such interests. Because I want to assure you, it is AI that is connecting now the president to whatever is happening right now. Isn't it? It is AI. The tech fest. And that is the reason as to why we said this boring annual law conference, the boring annual law conference that used to happen, it had a lot of decorum. Like lawyers could even fear. Lawyers could fear, by the way, to go to the annual conference. I think it was something that was put for, should you call them high-end lawyers? Yeah? Of course, throwing us away, like, me always tell people I'm a downtown lawyer. When you go Kampala Road, for me, I'm the other side of downtown. I know there are lawyers this side of Upper Kampala who are doing well, but me, I'm the other side, downtown. So it was always our call as downtown lawyers that we need something that can also bring us together. So what we bring in our ideas, and that is why when as council we sat down, we talked about that issue of Tech Fest. And there was, and like last week there was the Africa Law Tech Fest. The world has changed. So that is how digital transformation, and I want to thank Mr. Tony who has really spearheaded this issue, that it is now digital transformation that is ensuring that the president can continue with the services that he does. The president is not physically here, but he's working, and he will continue working. So that is why we are bringing in this element of law, the Tech Fest festival that will happen on the 14th and 15th of August 2025. And we are going to make it a real festival, something worth remembering. You know, lawyers only remember, there is always one event that always gathers us together. It is the annual pre and the annual general meeting. For the young lawyers, I always encourage you, please attend. Now this is going to be massive because we are going to add high voltage to it. We are going to add voltage to the Tech Fest so that we make it worth remembering. The doors, the passwords, everything of the treasure I'm going to unlock so that we make the Tech Fest as much as massive as possible as it can be. Lastly, I would like to speak to the law development. I think this is law council. I want to speak to law council. Law council, we appreciate the services that you do, that you provide. But there is a situation that is on ground. Lawyers who graduated or who are about to graduate and are preparing for LDC are in a state of quagmire. They're in a state of confusion. They do not know what's happening. In fact, there are just rumors. I hear pre-entry will be back, or we might bring it next year. That is a state of confusion, which we believe that members of law council should provide certainty to members. There should be certainty. Members should know, are they preparing for pre-entry, or they are not preparing for pre-entry. Simple. Are they going to do pre-entry, or they won't do pre-entry? Why keep the students in confusion, in quagmire, in a state of darkness? I know the lawyers, the ones who have studied, don't fear pre-entry. But there should be certainty. There should be certainty. It shouldn't take long. It shouldn't take long. LDC made a symposium about this issue. Uganda Law Society, we have talked about this issue. Former Minister of Justice and Constitutional Affairs, Otafide, made a full paper about this issue. And I don't know why in Uganda we take two steps. In fact, you take one step in front, then you take 2 steps back. When you go to Kenya, they will tell you that once you graduate, you get your practicing certificate. Those things over here, prolonging the process of getting a practicing certificates, they don't work in Kenya. In Kenya, once you graduate, you get your PC, and that PC, you can even appear in the Supreme Court. Once you get your PC, the following day you can appear in the Supreme Court. And these are changes that have been done recently by Kenya. And Kenya is a developing country. You can attest with me that Kenya is a developing country. And that is the same spirit that I was telling you, that by the fact that the doors were open for an 18-year-old, a senior 6 person, to contest as a president, it is the same spirit. When I was asking the president of Kenya, what was the spirit behind removing the obstacle that we have in Uganda? Because in Uganda we say someone has not developed and therefore should be restricted. But the law has enough safeguards. The law really has enough safeguards. And those are the things that we shall be having a discussion with the Chief Justice and the Deputy Chief Justice to ensure that we can harmonize that situation. Without wasting a lot of time, on behalf of the entire council, the Radical Neighbor, I would like to thank you, our panelists, for being here with us. Thank the viewers, the online viewers, for being online and following up whatever has been transpiring vis-a-vis our physical participants. The organizers, rule of law department, among many others. Thank you so much for your time. I will end by, I think we already took the group picture, so I'll invite the MC to come and direct on the next agenda. Thank you.
Thank you so much. Let's give a hand clap to the Governor of Bank of Uganda Law Society for those beautiful words of advice and wisdom shared, cutting across the board regardless of the topic. He was giving general remarks. We thank you so much with the blessing that we have from Isaac K.S. Makade, Senior Counsel. We would like to thank you so much for your blessing, Mr. Treasurer. Now that you're in the house, we are sure there's going to be lunch. There's going to be soft drinks also as we eat the lunch. Thank you so much for blessing us. We want to thank you for the words of wisdom. We want to just reiterate a few things, just without spending more time. We'd like to thank the ULS, of course, for the Pro Bono Week that is ongoing, the advocates that have offered themselves out there in the field, like the Treasurer said. We'd like to thank Council Sheila Turia Singura, who is the head, Mariam Nansukusa, Obadiah Kamukama, and the Legal Aid Project with the 22 clinics across the country, where we have seen on our handles there are different efforts being taken to go to different places of hold up, especially the prisons, to go and give free legal aid. And that is what the Uganda Law Society is about regarding the legal aid project. So let's put them in our prayers as the ULS, the legal aid project officials and the staff that are moving out there. Of course, there are some inside here who are going to markets and going to the prisons. Tomorrow we shall have pro bono day over here in the house. You're all welcome. We shall also be giving our experiences in regard to how the week has gone as we crown the week of pro bono. We shall also use this opportunity to wind up the day, having heard from the treasurer, whose words we cannot add to. For that matter, ladies and gentlemen, we would like to close the day with special thanks to all members that have joined us, like has been said, and we look forward to an exciting next week. The Tech Fest is on. Let's not forget, it is something that we are advertising. We also want to give very special apologies from our intended third speaker, who, for reasons beyond his control, was not able to make it because we had earlier on arranged 3 topics to be discussed, and the last one was supposed to be a detailed interaction with the organizing committee that is behind the preparations for the Tech Fest. But like I said, beyond our control and also beyond his or their control, they were not able to make it. Nonetheless, they have sent apologies and will be with us as time goes by. We shall also communicate as and when they'll be coming. Ladies and gentlemen, I would like to thank you on behalf of the Department of Rule of Law and Litigation, headed by Afra, and having members like Gwenny. Thank you so much for the whole day, for the preparation. We'd like to thank the Comms Department, our colleague and friend, Adam, Nwamanya, and Stella. Thank you so much. We'd like to thank the IT department, headed by Ken and Sam in the house. Thank you so much for everything. The media, the Fourth Estate, the technical team, Drake and company. Thank you so much for the work. And the photography, thank you so much for everything. Would like to thank, most importantly, those that have attended the function, both physically and online. May the Lord be with you. Until we meet again next week, God bless.